Hello, everybody. Welcome. Thank you for coming today or joining us today. I'm David Rubin, partner in Nutter's Labor and Employment Group, and we're going to talk today about what employers need to know for 2021. I'll introduce you to the group here. We are joined by Natalie Capolazzo, Emily Grannon-Fox, and Chris Lindstrom from our Labor and Employment Group, and by Melissa McMurrow and Laura Marcel from our tax department. And today we've broken up the agenda to talk in really three sections here. First section is Natalie is going to talk to us about the ongoing questions about vaccines in the workplace. This has been a hot subject, and we've been getting a lot of questions about this over the last several weeks. And after Natalie speaks, we're going to talk about the American Rescue Plan. First, Emily will talk to the questions about employee leave policies and the COBRA implications or the COBRA provisions of the plan. And after Emily is done, Laura will talk about the employee retention tax credits. And after that, we've blocked off some time at the end for questions, so please submit your questions to the Q&A panel, and we'll be following those along. We're going to try to be asking some questions during the course of the program and then saving some time at the end for additional questions. So with that, I'm going to turn it over to Natalie Capolazzo to talk to us about vaccines.
Thank you very much, David. Hi, everyone. Thanks for joining us today. As David mentioned, I'm going to be speaking about vaccines in the workplace and questions that are arising around vaccination policies, proof of vaccines, and the like. So the first question that I think has really been top of mind for everyone is whether employers can require that their employees be vaccinated. And the short answer to this question is yes. Based on guidance from the EEOC, employers can require that employees be vaccinated as a condition of returning to or remaining in the workplace. And sort of the question that goes hand in hand with that is, can employers require proof of vaccination status? And again, the answer here is yes. Importantly, simply asking an employee whether they've been vaccinated or requiring an employee to show proof of a vaccine is not considered a disability-related inquiry under the ADA. But just a couple of points worth noting here in terms of best practices. If you're in a situation where you are requiring employee proof, that in itself, again, not an inquiry, not a disability-related inquiry, but if you start asking follow-up questions, if an employee specifically is not vaccinated, that could be considered a medical inquiry because it might elicit disability-related information. So if that's the case and you're sort of going down that path of asking an employee, well, why haven't they been vaccinated? Just be aware that you would sort of need to follow the traditional ADA analysis here of requiring that that inquiry is job-related and consistent with business necessity. So just sort of keep that in mind. And another best practice here is if you're going to require that employees show proof of vaccination from their pharmacy or healthcare provider, it might be prudent to warn the employees in advance not to provide any other medical information. So for example, if there are records generated in connection with an employee's vaccination that reflect eligibility, if the employee has a certain comorbidity that dictated when they became eligible, that might be considered a disability under the ADA, and therefore you probably want to avoid compiling that type of information along with vaccination proof. So if we could please flip to the next slide, the two main exceptions in this area. So again, general rule, you can require vaccination among your employees, but the two exemptions to be aware of are medical and religious. So for the medical exception, this would be a situation where an employee says, I can't receive the vaccine because I have a medical condition that prevents me from doing so. So this would sort of trigger the usual ADA analysis here. First being whether the unvaccinated person poses a direct threat due to a significant risk of substantial harm to the employee or others in the workforce. And employers should conduct an individualized assessment of various factors in determining whether this is a direct threat, the duration of the risk, the nature and severity of potential harm, the likelihood of harm, and the imminence of harm. And the obvious harm here would be exposing other employees in your workforce to the virus. But just keep in mind that this really can change over time, especially as more members of your workforce become vaccinated. So while early on it might be that an unvaccinated person poses a higher risk to other unvaccinated people, if 90% of your workforce is vaccinated, that risk of harm might have been found to have dissipated. So just sort of keep that in mind. And then again, the employer would be in a situation where an employee raises a medical reason or objection to the vaccine. An employer would likely be required to go through the interactive process to determine whether a reasonable accommodation is possible. So the obvious example would be having the employee work remotely. And just keep in mind here, this is just a general sort of point for ADA compliance. The employee doesn't have to use the magic words of reasonable accommodation. It will probably be enough if the employee says, I can't get the vaccine because I have X, Y, or Z medical condition. That's probably enough for you as the employer to then have to engage in that process. So then beyond that, certain realities just exist that might make it so that you cannot reasonably accommodate this employee. It would provide a hardship for you as the employer. For example, if you're a service provider and you are working with vulnerable or high-risk populations, having an employee who's unvaccinated simply just is not feasible and there's no accommodation. At that point, you would be permitted to exclude the employee from the workforce. And again, the EEOC's guidance on this point is that that doesn't automatically mean the employer should jump right to termination. The employer should assess whether the employee has other rights that are protected under other federal, state, local laws. So, but again, if you reach that point, the EEOC has made clear that you can ultimately exclude the employee from the workforce. And then the other exemption or exception to requiring vaccines is for employees who raise a religious objection. And the standard here is that the employee must have a sincerely held religious belief that prevents the employee from receiving the vaccination. And again, similar analysis here, the employer has to go through the process of providing a reasonable accommodation, assessing whether there's a direct threat, going through that interactive process with the employee to work out maybe it's scheduling or providing personal protective equipment. Then ultimately, again, the employer would be justified from excluding the employee from the workforce if there's no ability to accommodate. And just a brief note, the second bullet under religious, the religious exception here, can an employer require proof? That is a sort of a tricky subject, but generally no. The EEOC has made clear that unless you really have a strong objective reason to believe that the employee doesn't have this sincerely held religious belief, it's probably not prudent to try to ask for corroborating information. So just to touch briefly on confidentiality requirements here. So per the EEOC, all medical information about employees must be treated as confidential. And in this realm, this would include vaccination status, or if you're requiring proof of vaccination, that falls under this category. Medical information must be maintained separately from the employee's regular personnel records. And there are only really limited reasons why it should be disclosed. So it can be disclosed to supervisors or managers who need to determine whether there are any work restrictions or reasonable accommodations for the employee, first aid and safety personnel, and government officials investigating ADA compliance. Otherwise, this should really be kept on a need-to-know basis.
Hey, Natalie, I have one question for you before we move on to Emily, and that's we've been fielding a lot of questions over the past 2 months from clients about whether an employer should set up its own on-site vaccine clinic to make it easier for their employees to get vaccines, or to, quite frankly, encourage their employees to get vaccines. And I was just curious what your thoughts are on whether this is something employers should consider, and kind of the implications for doing so, especially now that as of Patriots Day in Massachusetts, everyone, all adults will be available, so you can set up this vaccination clinic for every employee of yours.
Absolutely. Thanks, Chris. I know that's definitely been top of mind for a lot of employers. Generally, I think that we would caution against setting up this sort of internal vaccination site or clinic at the employer's workplace, or even having an employer contract with a third party to administer the vaccine, just from a general liability type standpoint. But also, while the EEOC has made clear that asking an employee whether they've been vaccinated or not does not constitute a medical examination or disability inquiry, there are certain pre-screening questions that are administered to the employee right before they get their shot, and those could in fact elicit information about a disability under the ADA. So really, this would be a situation where the employer would kind of be conducting all sorts of medical inquiries. So really, for the purpose of just taking themselves out of that equation, it would be better for employers probably not to set up their own internal vaccination sites.
Before we move on to the next one, there are a bunch of really good questions here regarding vaccines, and so I do want to get to those after the session, after we complete the talking about the American Rescue Plan. But one relates just specifically to something you were just talking about, Natalie, and that is someone asked about storing the vaccine records themselves. I'm assuming they mean, you know, if when you collect information about employees who have been vaccinated, indicating they have been, how do you treat that information and where do you store it? Is that medical information?
Yes, thanks, David. So that would be considered medical information. The EEOC has sort of been consistent in their guidance that information related to COVID-19 as it pertains to specific employees is treated as medical information. So if you as the employer are collecting, whether it be copies of vaccination cards or just some sort of proof or documentation that the employee has been vaccinated, just err on the side of caution and treat that the same way that you would treat other confidential medical information under the ADA. Store it separately, have it as a need-to-know basis type of information, and just generally follow those rules with regard to any documents you have about vaccine status.
Great, thank you. So now we're going to ask Emily to speak to us about the American Rescue Plan, and particularly with regard to the leave provisions and COBRA. Emily?
Hi, everyone. Thanks so much for coming. I'm going to talk, there's so much in the American Rescue Plan, so we're going to pull a few things out of it. First, I'm going to talk a little bit about the leave entitlements that incentivize the Families First leaves to continue to be provided by employers. And I'll just we're all very familiar with the Families First leave entitlements now, but I'll do a brief recap. As you know, in April of last year, Congress passed the Families First Coronavirus Response Act. And under that legislation, employers were required to provide emergency paid sick leave, a bank of 80 hours, and then expanded family and medical leave for up to 12 weeks for the reason of school or childcare being closed. And for all qualifying wages paid under those leaves, either 100% or 2/3 of an employee's wages, employers would receive a dollar for dollar reimbursement through a tax credit up to the wage caps. And then in December of last year, under the Consolidated Appropriations Act, the legislation provided that employers weren't required to continue to provide the leave, but if they chose to, they would continue to receive the tax credits through March 31st of this year. And notably, it was the same bucket of leave. So if an employee had 10 hours remaining of emergency paid sick leave, they could only use that 10 hours through March 31st. It wasn't a new bucket. And then in the American Rescue Plan passed just this month, there were a lot of changes and additions to the Families First entitlements that continue to incentivize employers to provide that leave without explicitly requiring it. So for the emergency paid sick leave, there's a new bucket of 80 hours. So every single employee, if an employer chooses to provide that leave, gets a new bucket of 80 hours, regardless of how much they used under the Families First leave. And notably here, if they have any remaining, so say they use 70 hours, that 10 hours they had left is gone. It's a new reset at 80 hours. The American Rescue Plan also adds some new qualifying reasons, which are all at 100% pay. So the first 6, the quarantining, the experiencing symptoms of COVID, advised by a health provider to quarantine, caring for somebody with COVID, the daycare and school closure, and then the substantially similar. Those all still remain, but now employees who take time to get vaccinated, who are experiencing side effects from vaccination, which has been quite common, and need some time off, and then time spent getting tested after exposure to a COVID positive person, or if the employer requires it, which also became quite common. Those are 3 new reasons that employees can take the emergency paid sick leave, and they're all at the 100% pay up to the caps. For the expanded FMLA, a lot of changes were made for this. As you know, employees could only use the expanded FMLA if, for the reason that their child's school or daycare was closed for COVID-related reasons. Now, any of the 6 emergency paid sick leave reasons plus the 3 new reasons are reasons that an employee could take the expanded FMLA leave. If they're taking it for the expanded FMLA, it would all be at 2/3 pay. But another big change is that under Families First, the first 2 weeks of that extended leave was unpaid. It was kind of a waiting period. Employees could choose to use the emergency paid sick leave to have that first 2 weeks paid. Now, the entire 12 weeks, if an employee chooses to take that, is all paid at 2/3 of their salary. So the tax credit has jumped from $10,000 to $12,000. And although this isn't explicitly clear under the American Rescue Plan, it appears that employees may be able to qualify for up to 14 weeks of leave. So that 80 hours of emergency paid sick leave plus the 12 weeks of expanded FMLA leave for qualifying reasons. And now under the American Rescue Plan, there's some additional reasons where an employer could be disqualified from getting that tax credit. Under Families First, there's the anti-retaliation provisions, which everyone's familiar with, which is you can't retaliate against an employee for taking that leave or requesting such leave. There's new non-discrimination provisions, which provide that employers can't choose to give this voluntary leave to highly compensated employees, full-time employees, or employees with greater seniority. And another big provision in the American Rescue Plan relates to COBRA subsidies. Everyone's familiar with COBRA. It allows employees who've suffered a qualifying event to elect to continue their employer's health plan coverage, typically for up to 18 months under the federal COBRA law or a state mini COBRA law. Under the American Rescue Plan, there's now 100% premium subsidy for that continuation period from April 1st through September 30th of this year. It's not something that's paid to the employee. It will be paid to the employer, the health plan, or the insured, depending on the type of plan. But what's notable here is a couple things. Who's eligible? It's not any typical qualifying event. It's somebody who was involuntarily terminated other than gross misconduct, or who has their hours reduced during this time period, and who elects COBRA coverage. But it also offers a second chance to employees who who had those qualifying events were involuntarily terminated or had their hours reduced prior to April 1st, and who elected not to continue COBRA, not to go on to COBRA, or suspended their COBRA continuation coverage because it was too expensive. They can now choose to get back onto COBRA with an expanded election period under this law. Importantly for those folks, their COBRA continuation period ends when it would have ended normally. So it will end 18 months after the qualifying event, even if it happens in June, despite the fact that this COBRA subsidy extends through September. So that just means that your continuation period remains the same. You don't get a new 18-month bank because of this law. You're not eligible, or you lose eligibility if you're terminated for gross misconduct, or you resigned, or you later become eligible for health coverage from a new employer, or your spouse's coverage, or through Medicare. So one big thing that employers are going to need to remember are the required notices for the premium subsidy. Anyone who becomes eligible for COBRA between April 1st and September 30th is going to need a general election notice that discusses the subsidy, which is pretty typical, but there's also a special election notice that employers must provide to any employee who was terminated involuntarily or had their hours reduced prior to April 1st, who now may be eligible for this subsidy. That will be retroactive to April 1st. Employers have until May 31st to issue the special notice. So that's a deadline to keep in mind. And then finally, employers have to provide a notice that the subsidy is going to expire prior to the September 30th deadline, or whenever their COBRA coverage is going to end, except if the person becomes eligible for health insurance through another employer or through their spouse. And the notices, actually, the DOL put out model notices, the general election notice, the special notice, and the notice of assistance expiration are now all available on the DOL's website. And I think that's all I have, David.
Emily, there are a bunch of questions here as well. One, though, just came up, and just to be clear, I guess someone is asking, is the COBRA subsidy, is it available to someone who leaves voluntarily, who quits work voluntarily? Because someone who quits work, is you typically eligible for COBRA? It's still a qualifying event.
Not for the subsidy.
They would not be eligible for the subsidy.
Mm-hmm. That's right.
Right. And one last point before we move on, Emily, because this is another, I think, an important question. Can you just talk to us a little bit about the 500 employees limit and how that affects these benefits and rights that you've been talking about?
Sure. So no, that's a great question. The original Families First framework, which is that employers under 500 had to provide this leave, and eligibility requirements for employees, that the framework still is in existence. So it's still under 500 employees and the same eligibility requirements as with Families First.
Great. Thank you so much. And now, just want to make sure our time looks good. Want to turn our attention to Laura Marcel, who's going to talk to us about the employee retention tax credit.
Hi, everybody. Thank you for joining us. Chris, if you could advance to the next slide. So I'm going to be discussing the employee retention tax credit. So this is a refundable credit for wages paid to employees. It was first introduced under the CARES Act to encourage employers to retain their employees and to keep employees active on the payroll. So initially, we didn't see a lot of interest with this credit because under the CARES Act, an employer that received a PPP loan was not allowed to also take advantage of this credit. And most employers determined that the benefit they received under a PPP loan was greater than the benefit they would have received under this credit. However, in December of 2020, that rule was retroactively changed. And now an employer that receives a PPP loan may also take advantage of this credit. And again, that change was retroactive back to the effective date, which is March 12th, 2020. So the first question is, who is eligible to receive this credit? So the credit is available to an employer that meets one of two tests. The first test is that the employer's trade or business operations must have been fully or partially suspended due to a government order limiting commerce, travel, or group meetings due to COVID-19. And the second test is that the employer experienced a, quote, significant decline in gross receipts. So again, this is an either or test. The employer only needs to satisfy one of these two requirements. So what exactly constitutes a significant decline in gross receipts depends on the quarter for which the employer is seeking the credit. So under the CARES Act, which governs the 2020 quarters, gross receipts must be less than 50% of those in the same quarter in 2019, whereas under the American Relief Act and the American Rescue Plan, which both govern quarters in 2021, the gross receipts must be less than 80% of those in the same quarter of 2019. So it's easier for an employer to satisfy this test to meet the 2021 credit as opposed to the 2020 credit, because in 2021, there only needs to be a 20% decline in gross receipts, whereas in 2020, there has to be a greater than 50% decline. So the next question is, what are qualified wages? And this depends on whether the employer is a large employer or a small employer. So a large employer may only take the credit on wages paid to employees who are not performing services, and a small employer may take the credit on wages paid to employees even if they are still providing services. So like the definition of significant decline, whether or not an employer is a large employer or a small employer depends on the period for which they're seeking the credit. So under the CARES Act, which again is governing the 2020 periods, a small employer is an employer with 100 or fewer employees. And for the 2021 periods, which are governed by the American Relief Act and the American Rescue Plan, a small employer must have 500 or fewer employees.
Laura, this is Melissa. One of the questions I know that you and I have been getting a fair amount is, how do you count employees? How do you how do you head count?
Yeah, that's a great question. So headcount is determined based on the average number of full-time employees in 2019. So you look at your average number back in 2019, and that's the number that you have to go off of.
Thank you.
So the next question is, how much is the credit worth? So for wages paid between March 12th, 2020 through the end of 2020, so through December 31st, 2020, the credit is 50% of up to $10,000 in qualified wages per employee per year. Whereas for 2021, so from January 1st through December 31st, 2021, the credit is 70% of up to $10,000 in qualified wages per employee per quarter. So for 2020, the maximum credit that an employer can receive per employee is $5,000 for the entire year. Whereas for 2021, it's $7,000 per employee per quarter, so $28,000 for the year. So we're finding a lot of employers are interested in this credit now in 2021 because it's worth potentially up to $28,000 per employee, whereas in 2020 it was capped at $5,000 per employee. So the American Rescue Plan Act added 2 new categories of eligible employers, and these are only applicable to wages paid after June 30th, 2021. So this only applies to Q3 and Q4 of 2021. So the 2 new categories of eligible employers are recovery startup businesses and severely financially distressed employers. So a recovery startup business is a business that began operations after February 15th, 2020, and has less than $1 million of average annual gross receipts. And the maximum employee retention credit that a recovery startup business is eligible to receive is $50,000. And the second category of the newly added eligible employer is a severely financially distressed employer. And this employer is allowed to treat any wage as a qualified wage, even if it's a large employer, as long as it had a decline of 90% or greater in gross receipts in Q3 or Q4 of 2021, as compared respectively to Q3 or Q4 of 2019.
Laura, I have one more question before we send it back to David. There's a term that you've used in this context. I just want to make sure that we underscore what it means, and that's the term refundable. So can you just walk through what a refundable credit is and why that's important?
Yeah, so if the amount of the credit is larger than the tax that the employer actually owes, the employer will be eligible to receive a refund from the IRS at the end of the year. So it's very beneficial to employers because they don't actually need to have the full tax liability in order to receive the full benefit of the credit.
Right, and we're talking about payroll taxes,
Exactly.
right? And there's some details on which tax is credited on that, but I think that the numbers are the important story that you're telling, so thank you.
Thank you very much, Laura. And before we go back to anyone else, there are a bunch of questions here. So let's just stay on that same subject. Laura, someone asked, is there a deadline to file for the credit?
So there is a deadline, but it's still open. So to file for the credit for 2020, if you've already filed the Form 941, you can file an amended 941, which is Form 941X. And if you haven't filed your Q4 941 for 2020 yet, rather than amending earlier quarters, you can just claim the entire credit on that fourth quarter Form 941.
Okay, and one more, and I think I'm thumbing back through your slides here because there's 2 or 3 questions here that seem to be a variation on the same issue, and that is talking about, an employer who meets one or two tests. One is significant decline in gross receipts, and the other was suspension of the trade or business. And so I think a lot of people are talking about falling sort of in between on some of this. Like, so someone asks if it's a multi-branch, this is a bank, I guess, a multi-branch bank, and one or more branches closes, but not all of them, and others remain open. Is that a suspension in trade or operations?
That's a good question. So it's very facts and circumstances. It needs to have more, the government order needs to have more than a nominal effect on the business. So for a bank, for example, if the government order prevented people from entering the lobby, but you could still provide all of your services through, say, a drive-through ATM or some way other than the lobby, then that would not count. So yeah, it needs to be more than a nominal, have more than a nominal effect. And one other thing notably that doesn't count, if there's a stay-at-home order, so your customers really can't even go out or they're not supposed to, that also does not count.
Got it. Okay. Then moving backwards a little bit, Emily, someone asks, oh, I like this question. So in Mini Cobra, some employers who have, I think it's fewer than 25 employees. Is that the Cobra standard? I think it's 25. 25 participants are eligible participants. So some small employers may not be covered by Cobra, the federal law, but are covered by the Massachusetts Mini Cobra, one of the other state Mini Cobras. Does the law work the same in that instance?
Yeah, so Mini Cobra is covered here too. So they need to provide the subsidy for if you're covered by Mini Cobra as well. I think what differs is who gets the credit, and I'm not exactly sure. It depends on what type of health plan it is, whether the employer gets the credit, whether the insurer gets the credit, whether the health plan gets the credit, but Mini Cobra does fall under the subsidy.
Okay, and I will say that there have been a couple of questions about who gets the credit in various circumstances. Like, so under a larger employer who is covered by Cobra, who gets the credit there?
In a larger employer, it would probably go to the group health plan. And I did see a question in there about whether when an employee has been paying the subsidy, say, and then becomes eligible for this, like how do they get reimbursed for the payment? And in that case, the employee, if they've been paying and were eligible for the subsidy beginning on April 1st, they could contact their employer or the group health plan and get either a credit on future payments or get a refund in certain circumstances.
I see. Okay. Well, not to leave you feeling left out, Natalie. There were a couple of really good questions, and I think a lot of people had the same issue, you know, over the last couple of days thinking about it. With the J&J vaccine controversy going on now, and the fact that, you know, these are all of these vaccines are emergency, you know, had emergency approvals. What didn't go through the standard approval standards. You know, can people have the right, employees have the right to say, no, I'm not willing to risk that. I don't trust them.
That's definitely a good question. I know that's been top of mind as well. So really right now we are looking at the EEOC guidance and what the EEOC is saying on this. And back in December, when the EEOC first issued their guidance on vaccinations, they made clear that the status of the vaccines is still FDA emergency use authorization, but still proceeded to say that employers can exclude employees who aren't vaccinated from their workforce, provided the employer has gone through all the steps of the analysis, reasonable accommodation, direct threat, etc. So really for that purpose, that distinction isn't entirely material. An employer still can proceed with mandating or requiring employee vaccinations, even though it's still in this emergency use authorization phase at the FDA level. That being said, one thing that employers should be aware of, especially those operating across multiple states, is that some states have proposed legislation that does distinguish between the status of the vaccine as being in this emergency use authorization phase versus what might happen later on when it's no longer emergency use. And some of that legislation is saying employers can't mandate vaccination when the vaccine is in emergency use, the emergency use stage. That's proposed legislation, and it's sort of in different forms across different states, and nothing in Massachusetts on that right now, but just something to be aware of that and keep an eye out for, that's kind of lingering out there and could be an issue. But as of now, we're following EEOC guidance, and the EEOC has made clear that employers can proceed with requiring vaccines even though it's in that stage.
Thanks. Chris, if you don't mind, I'm going to actually direct this question to you, because I know this is something you and I have talked about, and I see there are a bunch of questions on this coming up. And that is, and mind you, you're still on mute. And that is, what are companies doing? Are other companies, are they requiring or mandating vaccines? Or are they going to allow people to continue to work from home? What are we hearing from our clients?
So far, I've seen it. It's not the best answer for people in terms of an authority, but it's been across the board. We have certainly had some employers who are mandating it. Other employers are considering whether there are certain incentives that they can provide to employees that do get the vaccine. I've been cautious to go too far down that road. I'm more of the camp of you should either mandate it or not. But what we've found is that for those employers who are mandating it, they really are being thorough and thoughtful in terms of the reasonable accommodation analysis. Because we are finding that most employees want to get the vaccine for those that are eligible so far, and for the few that don't, employers are really trying to determine if they can have these people work remotely for at least the time being. Especially because of those reasons that Natalie just discussed in terms of the emergency use authorization. But we have certainly had employers who are mandating it and absolutely requiring it just for, so that every other employee at the office or at the facility feels comfortable enough that the employer is doing everything to keep them safe during these times.
Well, and I guess as a follow-up to that, I'm not sure if to you or to Natalie, but someone had asked, well, what about the 1 or 2 people that haven't had it? If you haven't, you're not mandating it, but you've got 10 of your 11 employees have had the vaccine. What about that 1 employee? Does that employee, do you have to continue to require that employee to wear a mask? Are they subject to different rules?
So that's definitely a good question. And I think this sort of goes to the point of employers having to sort of actively monitor what constitutes a direct threat to the individual and others in the workforce. If the nature of the workplace is such that it's fairly contained, and maybe employees are in separate offices and one person isn't vaccinated out of 50, maybe there's less of a risk of substantial harm resulting from that one employee's refusal or failure to become vaccinated. But if it's 1 in 50, but the nature of employment is such that that person is interacting with customers or working external to the out in the community or external to the employer, that direct threat substantial harm analysis really changes. So it's probably not such a helpful answer, but a lot of it depends on the nature of the workforce, and as time goes on, the percentage of other employees that are vaccinated. I think that's really going to impact this analysis of what it means when a handful of employees won't get vaccinated and whether that is something the employer can take action on.
Thanks. And I think it's fair to worth mentioning again, and the same advice we've all been giving all along, and that is, until we're told otherwise, it's advisable for all employers to follow CDC guidelines, follow state and local regulations and guidelines, and that's how you protect yourself and your workers. And again, until we're told otherwise, we're just going to keep saying it. There are a bunch of questions here, Laura, for you, and unfortunately, I don't know that I understand the subject well enough to really dissect some of the questions, but some of it goes to, I think, how do you define gross receipts or loss in gross receipts? So what counts for that purpose?
Yeah, that's a great question. So gross receipts for this purpose is the same as under section 448C of the Internal Revenue Code.
Oh, I got it. Sorry.
So I think I saw a question asking if it includes allowances.
Yes, we got that one is in here.
Yeah. Let me just scroll through and see if there's any more. But so the short answer is it's calculated the same way it would be on your tax return.
Okay. What are allowances?
Melissa, do you want to take that one?
Oh, sure. Just, well, one example would be uncollectible or something like that.
Nice.
Yeah. This is a great time to call your accountant because they have been really in the weeds on things like that. And there are, not everyone qualifies, and the questions that people are asking are really good, and they're getting to, what if you're kind of in between the two, you feel like you should qualify, but particularly with the roles that were in the CARES Act, you can fall through. And I think the bank one you mentioned, Laura, was a good one. But I think the bigger point is the rules are now more generous. Both in who qualifies in certain circumstances and in amount, and so it's worth a second look, and that it's retroactive.
Right.
Thank you. And then I guess along the same lines, someone asked, well, what if your sales didn't specifically drop or your receipts didn't specifically drop, but your business suffered regardless as a result of the pandemic? I mean, and I suppose that could be from increased costs, from loss of sales down the line or receipts down the line, you can see that your pipeline is dried up. Mm-hmm. So is that kind of business going to get any kind of relief out of this?
So it definitely could. So because it's an either or test, you don't have to have had a significant decline in gross receipts. So in order to satisfy that first requirement, the full or partial suspension, there would have had to have been a government order, and that needs to have been what affected your business in a negative way. So again, it's very facts and circumstances specific to each client's individual situation.
Thank you. Emily, a couple of questions have come up as to whether employers can offer just the sick pay leave and not the family leave, or vice versa.
That's a great question. We've gotten that one a lot. Unfortunately, the Department of Labor has not issued guidance on these provisions of the American Rescue Plan. We've been waiting with bated breath as an explicit answer to that question. We think that based on the language of the statute and its voluntary nature, that employers can choose to provide one and not the other. For example, they can choose to provide the 80 hours and not the more burdensome expanded FMLA, as long as they provide it in compliance with the other terms of the law. So for all of the 9 reasons and not discriminate against certain classes of employees, for example. But we're waiting for confirmation on that from the DOL. And if I could, I had a little chart that I hadn't memorized on the earlier question. I want to clarify who gets the tax credit for COBRA.
Sure.
So for insured state mini COBRA, the insurer gets the tax credit.
The insurer, did you say insurer?
Yeah, the insurer. If it's a self-insured plan, or if it's an insured plan subject to federal COBRA, the employer gets the credit.
Okay. Thank you. Natalie, I don't want you to feel left out here. So someone asked one of the very first questions we got actually was, what about a medical exception like pregnancy or breastfeeding? Would that be regarded as a disability? Would that, be an exception for someone?
So that's a good question. Generally speaking, pregnancy and breastfeeding are not considered disabilities under the ADA. Certain conditions related to pregnancy could be, but this might be an area, I think, sort of what Chris described. I think employers probably are wise to, in this situation, maybe see if they can work with the employee, even though it's not strictly required under the ADA to accommodate pregnancy or breastfeeding as a disability. Remote work or something similar might be just a way to sort of strike a middle ground in this area, even though, again, not strictly a disability under the ADA that would trigger these compliance issues, but probably worth finding some sort of middle ground.
And I would think, I have to think that it would, even if, you got around the ADA issue, you'd be violating the Pregnancy Discrimination Act or the sex discrimination law. So I can't see that not ultimately being an exception. I certainly can't see an employer taking that risk. I mean, that would be
agreed.
I think one of our mantras over the past year has just been for employers to be reasonable in how they approach everything. And if you have an employee who is pregnant and comes to HR and says, I don't feel comfortable taking a vaccine because of my pregnancy, and it's, these are untested vaccines so far, I would think you would find a way to work with that employee without too much fear of creating an exception that is going to cause, a flood of folks to come and try to get out of the vaccine, if you will.
Thanks. And going back, I guess to both you, Laura and Melissa, and this is a question that we see coming up, the extent that employers are going to continue to allow employees to work remotely. That seems to be, likely, I think, for the foreseeable future. What does that do for payroll taxes, withholding, all of those kinds of issues that, employers kind of have to deal with?
Yeah, that's a great question. So if an employee is working in a different state than the state in which the employer is located, it can potentially cause nexus for the company. So if it triggers nexus in that state, the company will be required to pay state corporate income tax or franchise tax in the state, and may also be obligated to collect and remit sales tax in that state. So employers definitely need to be conscious of, with employees moving around, which states does the company now have such a substantial relationship with that the state can impose these taxes on the company. And then, like you were mentioning with payroll, companies generally withhold personal income tax on salaries that they're paying to employees to cover the employee's state income tax. So
they're in-state income tax, the state in which the employer is located.
The state in which the employee is located, correct.
Where the employee works out of, I should say. Is that right?
Correct.
So if someone's, and I don't mean to interrupt you, but just so I'm clear, if someone is commuting from Providence into Boston, or from upstate New York into Springfield or whatever, the employer in Springfield or in Boston is going to be withholding mass taxes on that employee. Is that right?
So that's a great question. It depends on the state. So Massachusetts has taken the position that if an employee was working in Massachusetts prior to the pandemic and now is working remotely from a different state, so say New Hampshire, for example, which does not have a state income tax, Massachusetts has taken the position that the employer still needs to withhold Massachusetts income tax on that employee's salary, even though that employee has been working from New Hampshire for the past 12 plus months. So New Hampshire has actually sued Massachusetts over this, and it's gone up to the Supreme Court, so we have to wait and see what happens. But so the short answer to your question is it depends on the state.
And I think you made a good point too, Laura. There are some states that have interim COVID specific rules about this, right? So to flag that.
Yes.
Like we were saying when we were getting ready for this panel, these issues have always existed, right? These are not new issues. So there is law out there, but there is some states have issued interim COVID-19 rules.
Yeah, and some states have been pretty forgiving, and they've said both with respect to corporate nexus as well as withholding from salaries. They've said if an employee is in our state only because of COVID, they're working remotely only because of COVID, we're not going to impose nexus on the company, and you don't need to withhold or remit state income tax with respect to the employee's salary. So it's just a state-by-state analysis.
Got it. Thank you. I like this question, Natalie, so I'm going to jump back to this one. What about someone who says, I've already had COVID. I don't need to get vaccinated. I've already had COVID. I truly don't know the answer to this. So have you come across this in your reading, or?
Well, so I think that it's not a guarantee that an employee can't get COVID again. So really, I don't think the fact that an employee has had COVID already changes the calculation in terms of requiring vaccines. I don't think it's a medical exemption because it's not akin to a disability. If you say, well, I don't need the vaccine because I've had COVID, really, I don't think that having had COVID previously should change or create some sort of carve out if an employer is requiring vaccines.
What if the employee's doctor, advises him not to have the vaccine or to hold off on having the vaccine?
Well, I think that then having that that documentation from a medical provider would be sufficient in that situation. That would be my best advice, just to follow what the healthcare provider is saying. But again, just generally, I don't think an employee saying without more, I've had COVID would be enough.
Got it. And Emily, and maybe these will be our last group of questions. I think we're running towards the end here, but There were several questions about COBRA, and they were sort of granular, so I'm not sure how easy these will be to answer, but someone asked, and I'll read the questions. COBRA subsidy eligibility is for employees terminated as of April 1. Is there a look back period?
That's a really great question. So the premium subsidy is available for COBRA continuation coverage that occurs through April 1st to September 30th. So if somebody was involuntarily terminated last June, say, and they still had some period of that COBRA continuation coverage that crossed through April and September, they'd be eligible for the premium subsidy for April through, well, I guess through September, whatever the 18-month period goes through. So the look back is really just anybody who became eligible, who has a period of continuation coverage that runs at least partially through the April to September period.
Okay, thank you. And then, let me see if I could just find the same one. Someone had asked who polices the dependence on COBRA. So is there a well, I'll leave it to you. I think you see, looks like you understand the question.
No, I think there's a lot of open questions there that the guidance the DOL has put forth doesn't really cover. Like, for example, the dependence issue when somebody becomes ineligible because their new employer has health coverage or because their spouse has health coverage they can jump on. How do you know that as an employer? It's not clear how that's going to be policed. If a person wants their COBRA would prefer to get their COBRA continuation for free rather than get on their spouse's plan or something like that. It's not clear how that's going to be policed.
Got it. And I got one more. I'm gonna ask you, and maybe Laura, maybe you know the answer. I don't know, but is there updated postings or posters that employers are supposed to put up regarding the requirements of the new law? Do you know?
So the extension of the leave entitlements, there has not been anything issued by the DOL at all. So there's no new required postings. If you're going to offer it, I saw a question in there about documenting it. I would just suggest doing a communication to all of your employees that you're electing to provide whatever leave you choose to provide. And then, you submit for your the tax credit as you did under Families First. For COBRA, there are 3 model notices that the DOL has issued. The general election for somebody who becomes eligible after April 1st, the special election, which is those folks who got terminated, say, a year ago and now may be eligible for some part of the subsidy period. And then the notice of the assistance expiring. So those are all posted now.
Thank you. And then, so I'll throw it out to any of you. Does anyone have anything that we didn't address or that you wanted to get across before we part? Any of our panelists? Looks like we're good. Well, I want to thank everyone for coming. This was terrific. Really enjoyed it and hope to see you again soon. Let us know if we can be of any assistance or if there's any information here that you'd like us to follow up on. And I know that we'll be sending out copies of the PowerPoint and a couple of aids along with it. Thanks. Take care.